Morning.
Can you hear me?
I'm here. Hello.
Yes, I can hear you.
Okay, good. Are my birds too loud?
I don't know if I'm here for the right hearing. I'm here for the Walker case.
Okay, that's not me. I'm here for a different case.
Okay. In that case,
Sorry, can you folks hear me now?
Yes.
Yes.
Yeah.
Yes, Your Honor.
yeah, I might be on the wrong
Okay,
case, Your
so
Honor.
if I could have everyone else be quiet, please. I had to switch courtrooms this morning with Judge Claren, who's using mine to do some involved preliminary examinations. I just wanted to let everyone know that I am now here. We finally have the technology working. I just want, somebody's got a YouTube channel streaming in the background. Maybe it's me. Hold on a second. Yep, it is me. I should look before I scold you. All right. So I'm going to call Jackson versus Epperly first, and I'm going to boot the rest of you back into the waiting room. Who is on that file?
Keith
I
Schroeder
am
on behalf
Heather
of Mr.
Jackson.
All right. So, oh. You get to the right window here. Sent somebody out that I shouldn't have.
Good morning.
Good morning. We're getting there. So on this one, I've got Mr. Schroeder, Mr. Lancey, and are there some parties present as well?
There are, we have Michael and Danico and Heather Jackson, and then Rylan Jackson, the minor, so that you can see her scarring.
Are they all at the same location?
Yeah.
Yes.
Oh, there they are.
Your Honor, this is Carol Adams. I'm not supposed to be in on this hearing. I'm on
All
another
right,
one.
I'll put,
And
you.
Michael Delay as well, Your Honor. Please boot me.
and I'm not sure who this is. All right, does it look like we have everybody here who's supposed to be here?
We do, Your Honor.
Good. Shannon, would you put us on the record, please? All right, sorry for all the delay and confusion this morning. I'd like to say none of it was my fault, but I can't truthfully do that because I couldn't remember one of my passwords. Everything's all set up upstairs in my courtroom, but down here, not so much.
You have
Okay,
to,
counsel, state your appearances, please.
Sure. Bob Lancy for the plaintiff.
Keith Schroeder on behalf of the defendants Epperly.
And present on the other screen are, could you state your names, please?
Heather Jackson. Rylan.
And Michael Danico.
Okay, so we're here for approval of a settlement on behalf of a minor.
Correct.
All right, go ahead, Mr. Lancy.
Thank you, Your Honor. And if we could have the clerk swear in Heather Jackson, who is Ryland's mother and next friend. I'll take testimony from her.
Ms. Jackson, would you raise your right hand, please? You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Heather,
Put your hand
how are
down.
you re-
State your full name for the record.
Heather Lynn Jackson.
Go ahead, counsel.
Thank you, Your Honor. Heather, who is the young lady to your left there?
This is my daughter, Rylan.
And then Michael, how are you related to Rylan?
She's my daughter.
Got it. Okay, so Heather, you were appointed as next friend to represent your daughter in a dog bite lawsuit. Is that correct?
Correct.
And you retained our law firm on a 1/3 contingent fee basis. Is that right?
Yes.
And you understand that we proceeded through discovery, we attended a facilitation, and we ultimately came to an agreement with the defendants to settle the case for Rylan in the amount of $100,000.
Yes.
And you understand that by settling this case as Rylan's next friend, that you're forever waiving her right to proceed on her own behalf once she turns 18.
Correct.
You understand that by settling the case as her next friend, that you're forever waiving her right to a jury trial in this matter.
Yes.
You understand that a jury trial may have resulted in a verdict more or less than the $100,000 that we've agreed to settle for.
Yes.
Do you feel that this settlement is in the best interest of Rylan?
Yes, I do.
You understand that by settling this case today, that neither yourself nor Rylan nor anyone else will ever be able to proceed against these defendants for this dog bite incident?
Yes.
The settlement amount was was $100,000. You understand that there's an attorney fee in the amount of $31,727.72.
Correct.
Costs are in the amount of $4,816.84.
Yes.
You understand that we're asking the court to approve payment of a payoff of a medical lien to Cigna in the amount of $1,040.38.
Yes.
And then you and I are asking the court to approve an upfront cash payment in the amount of $4,915.06 for Rylan's current needs and benefits.
Correct.
And then you understand that the balance of the settlement is going to be placed into a structured settlement annuity. Is that right?
Yep. Yes.
And you understand that the payouts for the annuity, and I'm looking for the sheet, and looks like in the order, I have a $10,000 payout on November 27, 2030, a $10,000 payment on November 27, 2033, a $12,500 payment on November 27, 2035, a $15,000 payment November 27, 2037, a $15,000 payment November 27, 2040, and then a final payment of $20,400 November 27, 2042. You understand those are the payouts for the structure?
Correct.
And you understand that neither yourself nor Rylan will have any access to these funds other than on the stated payout dates?
Yes.
I'm I believe those are all the questions that I have at this moment, Your Honor.
You have any questions, Mr. Schroeder?
Yeah.
Thank you, Your Honor.
I apologize, Keith, just a moment. And, you know, for Your Honor, why don't you take the phone, Heather, and show the judge the scarring on Ryland's cheek so that he sees that for purposes of the approval.
Your head a little bit.
You gotta turn it the other way, honey.
Yeah. Keep turning.
Oh, oops. Let's see if we can.
You're not holding it right.
Just point your finger to it, Heather.
Yeah, over Zoom, scarring isn't even visible, so thank you, counsel.
Okay, I'll pass to you, Keith. Sorry.
Ms. Jackson, you understand that this settlement being paid out by Farm Bureau, again, is a final settlement of any and all claims that your daughter may have, past, present, and into the future,
Yes.
regarding the dog bite incident of July, excuse me, I have the date wrong. July 27th of 2019.
Yes.
Okay. And your daughter, if the court approves this settlement, your daughter would not be able to bring suit against either Farm Bureau or either Mr. or Mrs. Epperly ever with respect to this incident that we're here about, correct?
That's correct.
And you understand that this settlement includes any and all medical bills that may have been incurred or will be incurred in the future.
Yes.
Counsel, I forgot to ask, I assume there is no Medicare or Medicaid lien of any sort?
There is not.
Okay. And Ms. Jackson, on behalf of your daughter, do you think this is a fair settlement and you wish the court to approve it?
Yes, I do.
That's all I have, Your Honor.
All right, thank you, gentlemen. I do find that the settlement is reasonable and in the best interests of Ryland Jackson Danico. I'm going to date and sign it, and counsel will make sure that copies get forwarded to you promptly. Thank you for your patience this morning.
Thank you, Your
Thank
Honor.
you.
Ryland, it was nice to meet you.
Say thank
Yep.
you. You too.
Thank you.
Bye, guys.
Yeah, thanks, Bob.
All right. Talk to you later, Keith.
Okay.
Okay.
Okay, next up, let's see, Bam versus Barron. And Mr. Marienfeld is there. Mr. Creeder. Okay, this is the matter of Bam versus Barron. I see both counsel are present. Ron Marienfeld for the plaintiff. Mark Creeder, K-R-E-T-E-R, for the defendant. Is there anyone else you are expecting to be present?
No, Your Honor. The other counsel for the other defendant emailed that he was not going to be here today.
Okay, so Mr. Marienfeld, do you want me to swear your witness?
Yes, please, Your Honor.
So Ms. Bam, would you raise your right hand, please?
Just so my,
I couldn't hear any of that, ma'am.
I think I need to move my
Oh,
Wait till we
we
can get back
lost
to
her.
normal, Your Honor.
Your Honor, this is Mark Slater. Can you hear me?
Painful.
Can you hear me now?
Yes.
Yes, that's much better. Raise your right hand, please. You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You can put your hand down now. State your full name for the record.
Lindsay Christine Boone.
Go ahead, Mr. Marienfeld.
Hi, Lindsay. You are the mother of Evangeline Bam, correct?
Yes.
How old is Evangeline now?
12 now.
And back on November 17th of 19, she was with your mother at the time, defendant Aaron, and went over to defendant Patrick's house and unfortunately was bitten by his dog. Is that your understanding?
Yes.
How is she doing now in regards to the injuries?
the injury, she's healing. The scars are healing. You can still see them. I mean, it's scars. They're right there on her face, but she's healing up, you know, tremendously, more, a lot more than I just saw the pictures recently from the beginning of when it happened. And it's kind of remarkable how well she's doing in terms of what's happened. So medically, she's healing just fine.
Good. Now, we had talked, obviously this case was in litigation, and we had discussed that there were some insurance coverage issues and there was a declaratory action filed. Is that your understanding?
Yes.
That was one of the motivations for trying to get this case resolved sooner rather than later. Is that your understanding?
Yes, absolutely.
And if the court were to approve this settlement today, this would be a full and final settlement against both defendants and their insurance carriers, and we couldn't come back again later. Right?
Yep.
And if we, waiving your right to a jury, they could have come back higher, lower, the same, or zero. Is that your understanding?
Yep.
And after we have reached a gross settlement of $42,500, and after a reduction in the attorney's fees, there will be a net of $29,188.96 to go into a restricted account for Angeline. Is that your understanding?
Correct.
And on March 23rd, we have a hearing in the probate court to get you appointed as the conservator. Then we could deposit the funds and would have to file annual accounts and no withdrawals. Has that been explained to you?
Yep.
And there was, one thing I want to point out, there was a small medical lien, just over $300 that's going to be taken care of out of the settlement. Is that your
Yeah,
understanding?
and that was I'm aware of that.
And Evangeline's father has been put on notice of this hearing, as well as your future appointment as conservator, correct?
Correct. Yep.
All right. Knowing all these things, do you believe that the settlement is in Evangeline's best interest?
Yeah. I mean, it's unfortunate that this happened. It's obviously nobody ever wants their child to go through that. And it's unfortunate that we've still had to continue with it, but we're very happy to just move forward and put it behind us and just be done with it and just be able to have the emotions and not all of the continuation of, you know, all the time.
Well, Your Honor, unless Mr. Prater has a couple of questions, I would just ask that you approve the settlement. We have submitted an order. Obviously, it's pending the appointment of the conservator on March 23rd, which I don't expect any issues with that, but that's all I have.
Good morning, Your Honor. Can you hear me?
Good morning.
Good morning. Mr. Marienfeld covered everything well. have any questions.
Okay, is Evangeline with you now?
She's at school, so I don't have her available. I wasn't aware that she needed to be here.
I've got pictures which are very helpful, and I see the very last picture looks like there's only a very small remaining scar. Can you confirm that that's the case?
She has scarring on both sides still. They're visible. I'm not sure what the definition of small is. They're still visible, but they're healed. They're healing. She's doing well with it.
Yeah, I'm compared to the first pictures is what I was saying, ma'am.
Absolutely then, yes, there's significant improvement.
Any scar is too big for your child. I get that. But I needed to have some sense of how severe the scarring is to know whether or not this is a reasonable settlement. Based on the pictures and based on the circumstances that have been placed in the record, I do believe this is a fair and a reasonable settlement and that it is in your child's best interest. So I'm going to approve this. And counsel, I'll get a copy to you as quickly as possible.
Thank you, Your Honor.
Thank you.
Your Honor, I've got a 9:30 as well. Should I log off and log back in, or I don't know if you want me to just remain on here?
I might put you back in the waiting room.
That's fine. I'll go talk to my client and I'll see you in a little bit. Thanks, Lindsay. Thanks, Mark.
Thank you. Take care.
Okay, next up is the matter of Carnani versus Adams.
Yeah, let me. Yeah.
So you are Ms. Carol Adams?
Yes, I am.
Ms. Carnani, your microphone is muted.
Excuse me.
Well, I'm having trouble making a connection with Ms. Carnani. Either she doesn't know how to unmute her computer or we're not connected. I've got something showing that she's logged into the courtroom, but she's not responding. Will that phone reach up here, Shannon?
Nope. Because I think you can dial out with this one.
Yeah, why don't you bring that up here? Let me try that. Is there enough cord? I'll set it right here. Not many places to set
Yeah,
things.
Can you reach that?
Why did this change from gallery view? This doesn't even show that Ms.
Good morning, Your Honor.
Oh, okay. We were trying to call you.
Yeah, I guess I'm not showing up over there. I'm just my name.
Right. I don't have a video. So this is your motion for an expedited hearing?
No, Your Honor, that motion was denied. This is my motion to get my puppy back and for consequential damages. It was placed on your docket for today.
Hold on a minute.
Originally filed in February. And defendant was served on February the 13th.
I don't grant final relief in a motion unless it's a motion for summary disposition.
Well, Your Honor, then can we have a hearing on the matter, which is why I set it on your docket?
Are you at all familiar with the Michigan court rules?
Yes, Your Honor.
Claims she's a lawyer, Your Honor.
I used to practice law, yes.
Well, I looked. Your motion for an expedited hearing was denied. I don't know how you ended up getting on my docket.
I originally filed a complaint for possession of the puppy and for damages, and I was concerned that the puppy would be sold or given away, so I had requested an expedited hearing. Your Honor denied that, and I was told by the clerk that I was placed on your regular motion docket for today. If Your Honor would tell me how to proceed, I would be happy to follow your instructions.
Well, honestly, why don't you tell me a little bit more about your claim, because I'm puzzled why you're even in circuit court. Circuit court
Your Honor,
has let me finish. The threshold is more than $25,000 in controversy. How in the world is your complaint over this puppy worth more than $25,000?
Your Honor, may I give you the history of how this case arrived in your court?
Sure.
I had filed a case in district court, and Judge Goostree looked at it and said that it should be in circuit court, at which point I refiled in circuit court and was assigned to Your Honor. And that is how I am on your docket.
You don't claim this puppy's worth more than $25,000, do you?
No, Your Honor, I don't. As I said, I followed the instruction of the district judge to withdraw my case from district court and file it in circuit court.
And what relief you're asking the court for is to order that the defendant complete the transaction and deliver the puppy to you?
Yes, and I'm asking for consequential damages for unreasonable refusal to give me the puppy and for costs and fees that I've incurred in trying to get this done.
What's so unique about this puppy?
Your Honor, I met the defendant in January. She had a litter of 4 puppies. She brought 2 of them out for me to see. This is the puppy that I bonded with immediately. I went back to see the puppy about a week later, and she brought out a puppy, and I said, this one is not the puppy that I selected. And so she went back in and brought the other puppy out, and immediately I recognized him. He climbed up and licked my face, and we just bonded. And then she told me the dog was sick, and so I'd asked, how is he doing? And I said, oh, send me a picture or something. And she sent me a picture of the mom and 4 puppies, which is the complete litter. And she said, can you pick out yours? And I picked him out immediately. And she said, oh, I thought I could have fooled you, but I can see that you know the puppy. And I said, yeah, I know my son. I mean, I was being, I was joking and being lighthearted. So this is the puppy that I am attached to. The puppy is attached to me. I would just like to have this pet, Your Honor.
What's the total amount of time you spent with this puppy?
Probably an hour.
20 minutes.
Ma'am, I'll ask you a question
Okay, sorry.
when we're done.
So, Your Honor, it may have been an hour or
And
less.
in that time, you're telling me that you formed a irreplaceable bond with this puppy?
Your Honor, it's not irreplaceable. The thing is, I do not understand defendant's desire to refuse to give the puppy to me. She took my deposit, she's kept it. I repeatedly offered to come and pay her and take the dog. I do not understand the reason for this denial.
All right, well, let me hear from Ms. Adams. So Ms. Adams, what's your perspective on all of this?
Good morning, Your Honor. I've been doing this as a hobby for about 20 years. I've never had this happen, ever. I had a litter of 4 puppies. I advertised them on Hoobly with a $200 deposit and $650 due in 2 to 4 weeks. I sold them all in one day. She came over, she spent maybe 10 minutes picking one out, and she picked it out. They were about 2 weeks old at that time. However, for the next following, I would say 7 to 10 days, I received, oh God, more than 75 phone calls, text messages. She wants to come and see the puppy. She wants to take the puppy without me. She wants to take other people's puppies and go bond with them without me.
Don't interrupt.
You know, she constantly wants to come over. I'm telling her I can't let this puppy go. It's too much stress on the mother, and this is not my normal procedure. She kept it up. She kept calling and texting and calling and texting, and with the amount of stressors I have in my life, I couldn't do it. I said, look, I'm sorry, please come and pick up your deposit. And I'm still waiting on Sprint to retrieve my text messages, because I did offer at least 15 times, give me your address, give me your full name, I will get your deposit back to you, even though the receipt I gave her says non-refundable deposit unless you pay in 2 to 4 weeks. She didn't want to pay in 2 to 4 weeks. She wanted to pay at 8 weeks. So I said, this isn't working for me. I'm sorry, let me give you your deposit back. I just can't do this. She began writing multiple text messages saying, just let me come and pay for the puppy. And I started thinking, especially when she told me she was a lawyer, that this is going to turn into some kind of money seeking, you know, vet bills. There's something wrong with the puppy. You know, I could just see this happening. So the next thing that happened, she calls the police, who comes over to my house and wakes up my son, who works third shift, and demands the puppy. She wants to pay for the puppy, and she's demanding the puppy. Well, I wasn't home. My son's not going to release a puppy. And the police officer, you know, just basically, you know, comes to the same conclusion I did, that I think she's got some mental health issues, that, or she's just seeking monetary, you know, this is her job, I think, is just getting money, because this is just a puppy. It's just a golden retriever puppy. I don't know what else to say, except for I do have text messages that show where I said, hey, pay the money, come get the puppy and get out of my life. Just go. She wouldn't do it. She didn't want to do it. She wanted to file this court hearing. And the multiple messages that I said, come and get your deposit. She wouldn't do it. I just at wit's end. I don't want her contacting me. I'm considering getting a PPO if she doesn't stop contact with me.
All right, and anything further, Ms. Carnani?
Yes, Your Honor, may I respond? I have attached all the text between Ms. Adams and myself, for Your Honor, as an exhibit. I did not ever send her 75 texts or anything close to that. She had told me the dog was not well. I had asked if I could see him, and she said, no, I don't want to take him with a mother. And I said, I would not want to do anything to harm the puppy or the mother. I would see it when she gave me permission to. So she gave me permission. I went and saw it once more. Then she said the dog was ill, and I said, is he better? And then she emailed or texted all the owners saying the puppies are ready to pick up. This was January 21st. So on the 22nd, I texted her back saying, when may I come pick it up? And I think on the 29th, I think I did send her 3 texts saying, please, could you respond? It can't be that hard to just let me know that you will get back to me later. And then after that, I think a few days later, I said, you're a social worker. You understand how this can upset someone. I'm worried that the puppy died or something happened. And that's when she said, I'm not going to give it to you. And after that, I just said, look, I'm really sad. Could we do this? I did not go to her house to threaten her with the police. I took the policeman with me as a civil standby to ensure that nothing untoward happened. The officer and I told her to please call me. I would be waiting at the Jackson police station. I did not hear from her, which is when I filed this suit to get the puppy, Your Honor. I am not litigious. I don't do this. I don't even practice law anymore. All I would like is to get this puppy, get my costs and fees paid, and pay her the balance and take the puppy. She can deliver it. I do not need to go to her home. I would be very grateful if Your Honor would grant me my request.
All right, thank you. I've listened closely to both of you. I do not believe that you've met the standard necessary to obtain specific performance. I'm going to dismiss your complaint upon refund by the defendant of your deposit. Once the refund is made, the case will be dismissed.
Your Honor? Your Honor?
I'm done, ma'am. I expect you to pay her deposit back.
Okay, but she also put in the receipt where she gives up her deposit and also states in her text messages she doesn't want the deposit back.
I'm ordering refund of the deposit.
Okay.
And this morning, we're small claims court, apparently. Okay, let's see. Curvin versus Heim. Wondering if that got resolved. I don't see Rob Jakey. I don't see Rick Girardat, so I'm guessing they must have resolved it. And let's see. Walker versus Cole. That's Mr. Marienfeld. Mr. Marienfeld, I think I saw Attorney Delay in the meeting room earlier. I don't see him now.
Yeah, I'll give him a call real quick, Your Honor.
All right, I'll call my next case. Okay, this is the matter of Hilltop Manor Inn versus auto owners. Counsel, are you expecting anyone else to participate in the hearing this morning?
Nope, just us.
Okay. So this is plaintiff's motion for a protective order. And let's see, you are Zach Bonham?
Correct.
For the plaintiff?
Correct.
Go ahead.
Thank you. All right, Your Honor. So the reason why we're here today, really for this lawsuit, my client owns a piece of real property in Jackson County. Just a little bit of background on this piece of property. I'm assuming you haven't been there. It's a wedding venue business. There's a 3-story main house that is rented out to the parties that come there for the wedding clientele. Next to the main house, there is a separate garage, a 2-story garage that has been remodeled to like hotel rooms. So for other things that can be rented out. And across the street is a barn from the 1800s. That's where the actual, the wedding venues occur. So that just kind of gives you a little bit of an understanding of what the property looks like. There was a water loss on the 3rd floor of the main house back in January 2019. And the reason why we filed the lawsuit, auto owners did let's say 6 months insurance investigation into my client, the owner of the company. They didn't find any incidents of fraud. According to them, they paid out the entire claim in full, which if an insurance company thinks there's fraud, they don't pay it out in full. I've never heard of that. And so we filed our lawsuit because we're saying that the damages our client incurred exceeds what was paid out. That's why we filed the lawsuit. That just gives you a little understanding of why we're here. The reason why we filed this motion for a protective order is because now auto owners have sent a discovery request really with 2 main issues that we find. One's a procedural issue. They're asking for records, documents, and responses from non-parties. Namely, who we're talking about is Hilltop Contracting Incorporated, Hilltop Investments LLC, and Donald Kovalevsky individually. None of these companies and person are a party to this lawsuit. So they can't be compelled or required to provide any responses to a discovery request that they're not a party to the lawsuit of. That's the procedural issue. Now, the substantive problem that I'm having is that these discovery requests really amount to a pseudo creditor's exam. They're asking for copies of land contracts, payment history for land contracts, payment histories for civil lawsuits from 5, 6, 7 years ago for non-parties, financial records for non-parties. Aside from the procedural issue, substantively, it has nothing to do with an insurance contract between Hilltop Manor Inn and auto owners regarding a water loss that happened. So for these reasons, we're asking for a protective order. Now, that's the broad strokes. If you look at our Exhibit 1, our only exhibit, it's a copy of the discovery request that auto owners sent. And we're only asking for a protective order for items 5 through 9. And I'm happy to go through each one of them. I know I did so in my motion, and I'll just briefly touch on it without trying to say it twice. So for the sake of brevity, the number 5, auto owners asking for any documents or inspections for a guest house in the barn at the real property where the loss occurred. The loss didn't occur in this guest house or the barn. These are separate buildings. The loss actually happened in the main house. They have every record regarding this instance because we did over 6 months of an insurance investigation. They were the parties, or the attorneys for defendant are the same attorneys, so they have all the records. We turned over thousands of pages of records regarding this, but nothing about the barn and nothing about this guest house were a part of the loss. It didn't happen in those structures. So one of my problems is, what the heck does any documents mean? I mean, it could be literally anything. There's no restrictions on what that could be. So vague and ambiguous, unduly burdensome, harassment, all of those apply to this request. And also the inspections. I have no idea why a local township inspection from Liberty Township would have anything to do with a water pipe that burst in the main house. Also, these records that they're asking for, these inspection reports, those would all be public records. So if they want these records, they have equal access to them as we do, but there's no logical relationship between those records and the discovery request. And as I look at the response from defendants, they're now talking about there may be some kind of financial motive that led to this pipe bursting. Well, that makes no sense. They did 6 months of a discovery in the insurance investigation. I believe they did 3 depositions, 3 full-day depositions of Don Kowaleski regarding this. They did electronic surveillance of his cell phone. I mean, he showed up to a deposition one day. They had an expert waiting in a spare room to go through his phone and pull records off of it without us knowing that was going to happen. So they've done a full investigation of this issue of fraud if they thought that happened, but they paid the claim out in full. They didn't make any issue of saying that fraud occurred. They didn't file a civil lawsuit. They didn't file a counterclaim. They didn't file any criminal report. So for them to come back now and say, well, there may be a financial motive that led to this. Well, if they thought that, they never would have paid the claim out in full as they said they did. So for that reason, we're asking for a protective order.
So I'm puzzled. If they paid the claim in full, what remaining claim does the plaintiff have?
There was over $200,000 in damages that we provided to auto owners throughout the course of this insurance investigation, verifying the cost of the materials, cost of labor, the value of property. And they came back with I believe it was a $30,000 check saying this is what we owe. So we're filed a lawsuit saying that there's a significantly more that's owed out there. And they didn't pay the contract out like they were supposed to. That's the broad strokes of the lawsuit. So getting to number 6, they're asking for copies of land contracts, payment histories for, they say 3 properties, but it's actually 4 the way I read it. They have it for a property on Limerick Lane, a property on Woodbridge. I don't know what city or state that's in, but it says Woodbridge, 1009 Woodbridge, Irving Street in Jackson, and Oakwood in Jackson. Hilltop Manor Inn doesn't own any of those properties. There's no relation. They don't have a land contract. They don't take the payments for any of those. There's no logical relationship between our plaintiff in this case and any of those properties. They're not listed in any pleadings. They're not listed in the insurance contract. That's the underlying issue of the lawsuit. It's entirely a fishing expedition. So I have no idea why they would want those. Now, the response says Don Kowaleski owns many companies, and the companies he owns may own those properties. Well, Don Kowaleski is immaterial to this litigation. Because he owns properties, that doesn't mean anything. He's not a party to this. Any other companies he owns isn't a party to this litigation. So procedurally, they can't be required to turn over documents that they're not a party to. Subpoenas are required, not discovery requests. But there's no logical explanation why payment histories for these properties has anything to do with an insurance contract that was regarding a water pipe bursting. Number 7, they're asking for any and all notes made by Don Kowaleski from January 31st, 2019 to the present date. Again, vague and ambiguous. What the heck does any and all notes mean? It could be anything. Is it notes he made for what he's picking up at the grocery store? Is it something he's doing for a construction project? I have no idea what that means. So vague and ambiguous, also too broad. They haven't narrowed it down to anything. On top of the fact, Don isn't a party to this lawsuit. Any notes he would have made on that date would have been for litigation purposes, not discoverable. And also they were turned over to our office as items that would have been made for us. So attorney-client privilege applies. So those aren't discoverable. We asked for a protection order for that as well. They then ask in number 8, they want litigation records, including pleadings, judgments, settlements, payment agreements, payment history regarding the following civil lawsuits: Snap Advances LLC versus Hilltop Contracting and others, Abiji Bapa Partners LLC versus Hilltop Contracting and Don Kowaleski, and the last one is Hilltop Contracting versus Birmingham Donuts. You'll notice not one of those lawsuits includes our plaintiff in this case, Hilltop Manor Inn. There's nothing related between those 3 civil lawsuits and our plaintiff and this case. So if they want these records, they're public records, they can go and get them. But as far as our client turning them over, there is nothing for them to turn over because they're not a party. But on top of that, these parties that are here, being non-parties, can't be compelled to turn over records through a discovery request. And I'll go back to the idea that they did discovery for over 6 months, depositions, electronic surveillance of our client. There was no fraud found. They thought there was fraud, and they're saying that we need these records to prove some kind of financial motive. They've had that opportunity. They didn't find it. They claim they've paid the claim out in full. And I don't know an insurance company that pays out a claim in full if they think there's a financial motive for a suspicious loss. So we asked for a protective order on that. And the last one, number 9, they're asking for Hilltop Manor Inn and Hilltop Contracting to provide business records from 2016 to 19. I sound like a broken record here, but Hilltop Contracting is not a party to this litigation. They can't be required to turn records over procedurally, and substantively. It has nothing to do with this lawsuit. As far as Hilltop Manor Inn is concerned, we've turned over thousands of pages of records. What we have is what we have. We've turned over. They're asking for contracts with wedding clientele. Absolutely irrelevant to what this lawsuit is. They didn't file a counter complaint against us for anything. And as far as saying they need the contracts, what's the contracts going to prove? It's just unduly burdensome and harassment to go through and have to get all these together from 2016 to 2019. They want records in possession of our CPA. Well, if they know we don't have them and the CPA has them, then they need to go get them from the CPA, not from us. And then the business records. I'm not going to belabor the point, but again, they've had an opportunity to do discovery in the insurance investigation. They found nothing. This is just harassment for our client at this point to turn these things over. So we'd ask for a protective order for items 5 through 9, Your Honor. Thank you.
Thank you. Ms. Griffin?
Good morning, Your Honor. There's some facts that I would like to add or correct to what plaintiff's counsel has indicated. While Mr. Kovaleski, first of all, the businesses at issue are S corporations. They are all solely owned by Donald Kovaleski. Those, as court knows, that corporate income passes through the shareholders. So they are actually inextricably related in this case. Donald Kovaleski is the sole shareholder of Hilltop Manor. He's also the sole shareholder of Hilltop Construction, as well as some other businesses that aren't pertinent to this discussion. And it is Donald.
Let me stop you, counsel. I did read your response. My understanding of the particular methods of discovery you've chosen to use, interrogatories and requests for documents, are well, at least as far as interrogatories go, certainly, those are only available to a party.
And I agree, Your Honor.
And it is possible for you to do a document request from a non-party, but you got to serve it on the non-party. All you've done is submitted interrogatories and document requests to the named party. And even though I understand your point that these are all interrelated, you didn't even sue Mr. Kovaleski.
Well, we are defending his breach of contract claim. And if I could just give a little bit more background, Your Honor, all of the documents that we have requested actually were requested from Mr. Kovaleski during the investigation period. The fact that we took several months, much of that was because there were several changes within Mr. Bonham's firm. We dealt with several attorneys, and they made repeated requests for delays. In all, we made several demands which were proper under the provisions of the insurance policy that allows the insurance company to ask for the business records. What makes this claim particularly interesting is that the business operations, all of these are housed at Hilltop Manor. And part of the, what's so intertwined here is that it's a guest house that's used as a bed and breakfast and a wedding venue, but it's also where they kept the business records for Hilltop Construction. As part of the claim, they presented a bill from their CPA that said they paid over $12,000 to have all of the backup of the computer equipment that housed all this information. And then they actually said, had Mr. Kowaleski presented this as part of his claim, as part of his damages. And so when we asked for this information, despite showing that there, I'm sorry, not $12,000, I misspoke. It was over 12 hours of time that he billed for charging for those services. And then when we said, well, we need those records because we think there's a financial motive here as to what's going on, we want you to produce them. And he, despite having said, expecting, presenting that as part of his damages, he then claimed, I don't have them. I can't produce them. And they were, he had at the same time expected auto owners to pay for that service as part of his damages. We do think that there is very significant evidence of fraud here because Mr. Kowaleski's businesses, he has Hilltop Contracting, as we point out, he was facing litigation judgments and liens. These were all, he owed $150,000 in due to a settlement of a loan in which they placed a lien on Hilltop Manor as a result. He also, Hilltop Contracting claimed to have done mitigation repairs at Hilltop Manor. So part of Hilltop Manor's claim was also the services of Hilltop Contracting. He submitted an invoice or several invoices totaling over $40,000 that he said were his own cost for doing the mitigation repairs at Hilltop Manor by using his crew for Hilltop Construction. He then prepared a repair estimate for the damages at Hilltop Manor that was prepared by Hilltop Construction for over $80,000. So the claim, it isn't just that Hilltop Manor is the insured party here, it's that Mr. Kowaleski seeks to also use his other company to do this work so that he is actually getting the benefit on both ends from his business. There is evidence that he, with regards to the manor, he had testified had gone through over $100,000 plus in repairs and renovations, so that the building, that there's 3 buildings that's owned by Hilltop Manor, all the 2 that were not affected by this water loss, the barn and a second sleeping quarters, those had, he said, had gone significant renovations, and we were asking him for documentation. None of that he could produce. So the records, everything that has actually was set forth in this discovery request was stuff that had been repeatedly requested during the course of auto owners investigation, and none of those documents were produced. In fact, what Mr. Kowaleski did, we did take his deposition or his exam under oath for 2 days. He was represented by a colleague of Mr. Bonham. Mr. Kowaleski was very evasive during those proceedings, and he repeatedly claimed that he had turned over documents that it not. He kept saying that we lost his documents, even though every time the documents were produced, they had been bait stamped. And when we would send a supplemental letter explaining everything that was missing. He would either claim that he had produced them and that we lost them. Well, basically that's what he kept claiming. We had produced them and that we lost them. So it had been this constant shell game of moving things around. So if plaintiff had, instead of filing this as a motion for protective order, we would have, if they had just simply filed objections, we could have dealt with those objections. But we think this is simply a bigger attempt to prevent discovery, which goes to really, we think that he was facing settlements and judgments from his businesses being sued. He had taken out very aggressive loans that were coming to fruition and he owed money on them. The documents that we were asking for, which we said, counsel says are available for the civil cases. He had testified he had made payments on those. He didn't produce them. We had also asked for bank records through his during the investigation. And it should be noted that these bank records are not, they're commingled funds. So it's not as though he maintained separate business records. So this idea that we are going after other parties is misleading. So to the extent that I would agree that we could just separately subpoena them, and if that is something the court thinks that we should do, I would agree that procedurally that is another route that we could have taken. But just for clarity, everything that had been requested in the interrogatories had been requested multiple times from the insured, and including insured's counsel, because the insured's counsel has been involved in this case. At least the law firm has been involved in this case since the onset. We've dealt with 3 different attorneys. Mr. Bonham was personally involved in March or April of 2019. He produced some of the documents, not all of the documents we requested. We were then passed off to a different attorney, Mr. Kroll. He produced some, but not all of them. They asked for extensions to produce the documents. They didn't produce them. So we've kind of already been through the runaround on this. This is just, it wasn't produced when we asked for it in the investigation, and this is an attempt to not produce it again. And at the very least, if, as I said, we can directly subpoena those non-parties such as Hilltop Contracting and Donald Kovaleski. But I guess we had attempted to do this in one discovery request. But I will concede that that procedurally we still have the option to go through doing it as a subpoena. But I would anticipate that we will only be back here with plaintiffs moving to quash those subpoenas.
Well, that may be the case, but today I'm going to grant the request prohibiting discovery from Hilltop Manor of documents and records of anyone other than Hilltop Manor. So I'm going to limit the interrogatories and document requests to the ones that specifically request records of Hilltop Manor. As to anything else, you may be back again, but your discovery requests are inappropriate directed to the plaintiff. You need to direct them to the correct parties. Mr. Bonham, you'll prepare an order reflecting my ruling?
Yes, Your Honor.
Thank you.
Thank you.
Thank you, Your Honor.
Have a good day.
You too.
I've got to take a short break. I'm going to leave the thing running so I don't have to log on again.
Hang on, I almost want to go up and get another coffee. Sounding kind of good right now. See, now I can't, hang on one second. So Dawn sent me a note and said, aren't those things weird? And the Griffin, the lady, she said, aren't those things weird on the wall? And I'm like, I can't see that. I said, you know, I mean, just sitting from here. So she sent me a screenshot and I'm like, oh my God, I'm all up on there too. See, I've seen these on Wayfair though. Have you seen them? It's like they're people. It's like they're climbing a rope. Aren't they weird? But I've seen them on Wayfair and I said, oh my God, I'm right there too. I can't see that much of me when I look here. Like, I mean, I only see half of me.
Oh, really? Yeah,
But yeah,
your head does.
Yeah, she said, aren't these weird? Now I can't even, all I can see sitting here is her. But
Oh,
yeah,
okay.
aren't those weird? They are weird.
So is it like a coat hanger or something? Is it just purely
You know,
ornamental?
We were just discussing the people walking up the wall. It probably could be.
That's what I would
They were coat
guess.
hangers or if they were.
That's what Peter just said.
But I'm looking at it and I'm like,
Well, and I'm going,
Kind of a
what the
weird-
hell? What the hell is weird on the wall? I can't see anything.
so you,
We are streaming,
Oh,
just so you know.
I didn't insult anybody. I don't.
do you have 2 seconds to sign 3?
Sure.
I didn't say anything. I didn't insult anybody.
No, I didn't hear what anybody said. I just heard you talking.
We're just talking about weird figurines that were on Miss Griffith's wall that we didn't know if they were decorative or if they were coat hangers or,
And I didn't even notice.
because we can't see them. That's why Dawn sent me the screenshot. But I didn't realize I was,
You didn't know you were being
I didn't
shown.
know I was
should have
all up on there.
texted you
Yeah, I don't know
or
about
emailed
that.
you to let you know that if you were gonna laugh or.
All right.
You see my, you gone.
Chris Jennings is here for Mr. Giro Dat on the one case we skipped.
Oh, okay.
You don't see him in the waiting room.
Which case was that?
That was one where it was,
Jakey?
no, Curvin behind.
Yeah, I didn't see Mr. Jakey here. He is here now.
Yeah, I think they're both there now with Chris Jennings.
Okay. Okay, Shannon, put us back on. Okay, this is the matter of Curvin versus Heim. Counsel, state your appearances.
I'm Rob Jakey, P55829, attorney for the plaintiffs.
And good morning, Your Honor. Christopher Jennings appearing on behalf of defendant Billy Heim.
And this is defendant's motion. To compel discovery, I think. Is that correct?
Sort of, Your Honor. It's a motion to show cause against USA Insurance. We had sent them a subpoena back on December 1st of 2020, requesting the PIP files for Robert Curvin and Dawn Curvin. And as of this date, they haven't responded to the subpoena. So we were just looking to get a show cause hearing date set by this court to either have them produce the documentation or to explain to the court why they haven't produced the PIP files.
So you're asking me today to order USA to appear and show cause whether they should be held in contempt for ignoring your discovery subpoena.
Correct.
Do you oppose that, Mr. Jakey?
I have no objection to that, Your Honor.
I will grant that relief. You may submit an order if you haven't already. Hold on,
Yeah,
I do see a proposed. I see a proposed order. All right, I will sign your order. Well, wait a minute.
I think typically with these things.
Oh, no, I'm sorry. That order is an order to compel discovery. You want me to sign an order
To show cause.
to show cause, and I don't see that you submitted that. So you'll need to submit that order to the court. I will sign it upon receipt.
Do you have a particular date and time? We want to set it for like 3 weeks from today.
Oh, okay. You were looking for a time. 3 weeks today works for you. Are you on GIS, Shan? What is
yes,
3 Fridays from now look like? Why don't you set it for 9 o'clock on the 26th?
All right, thank you, Your Honor. We'll get the order submitted.
You're welcome. Have a good day, gentlemen.
Thank you, Your Honor. Thank you, Chris.
Take care, Rob.
Have a good weekend, everybody.
Go.
That date will be in the order, right?
Yeah, he'll put it in his order. I keep losing my mouse. Okay, this is a matter of Eric L. Walker versus Cole. Mr. Marienfeld for the plaintiff, Mr. DeLay for the defendant, and it appears that Mr. Eric Walker is also present. Mr. Marienfeld, this is your motion to approve wrongful death settlement and distribute proceeds.
Yes, may I take some proofs?
You certainly may. Mr. Walker, would you raise your right hand, please? Mr. Walker, can you hear me?
Here. Hold on, Your Honor. I'll find out what you If it could go wrong today, Judge, it's going wrong. Love this Zoom. Hopefully getting it fixed right now. You hear us, Eric?
Mr.
hear you.
Walker, can you hear me? Okay, would you raise your right hand? You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
You can put your hand down, state your full name, please.
Eric Lee Walker.
Go ahead, Mr. Marienfeld.
Hey, Eric, you are the father and the personal representative for the estate of Brandon Walker, correct?
Yes.
And obviously, we've talked about this, but sorry for the reason we are here today. Brandon was in a fatal automobile accident back on November 6th of 2018, correct?
Correct.
He was 19 at the time.
Yes.
And the case went to facilitative mediation, and we obtained a gross recovery of $80,000. Is that your understanding?
Yes, sir.
And the reason we chose to resolve the case, there were some serious liability concerns that we had discussed quite a bit, correct?
Yes.
And if the court were to approve this settlement today, you understand this will be a full and final settlement. We can't come back again and bring this case against the driver, owner, insurance company, or anyone.
Yes, I understand.
And we would be waiving our right to go to a jury who could have came back higher, lower, the same, or zero. Is that your understanding?
Yes, sir.
And with the settlement, there is a net, after a reduction in the attorney's fees that we discussed, there is a net of $63,583.27 to be distributed under the wrongful death rules. You understand that?
Yes.
And as far as the settlement goes, you believe that the settlement is in the best interest of the estate.
Correct.
Now, you also, or I'm sorry, Brandon had two brothers,
Yep.
one 17 and one 24 years old, and
Yep.
yourself and his mother, correct?
Yes.
And you all have discussed and proposed a distribution of $5,000 to each boy, and then you and Jessica, Brandon's mother, would split the balance, which would leave $26,791.63 for each of you, correct? Correct. And we have discussed that because the statute, I'll put the number out there more for the court than your benefit, but MCL 700.5102 allows settlements of $5,000 or less for a minor to be provided to the custodial parent. Have we talked about that?
Yes.
And both sons have agreed, and actually your older son, Colin, had just texted me yesterday saying that I am fine with everything. Whatever mom and dad wants to do is fine with me. Is that your understanding?
Yes, it is.
And do you believe that this distribution of the proceeds is fair for yourselves as well as your sons?
Yes.
Your Honor, unless Mr. DeLay has any questions, we would ask that you approve the settlement and the distribution, or unless you have any questions.
Your Honor, Michael
Mr.
DeLay on
DeLay?
behalf of Shannon Cole. I have no questions or any objections.
How old are the siblings?
24 and 17, Your Honor.
And which one is the 17-year-old? Bless you. Bless you.
Connor.
Connor. And Connor has indicated his willingness to accept this payment.
Yes, sir.
All right, I'm satisfied based on the testimony that this is a fair and equitable settlement, and I'm going to approve it today. We'll make
Thank you,
sure
Your
that
Honor.
we get copies to you as soon as possible. Counsel, thank you.
Thank
you,
you.
Your Honor.
Have a good day, Your Honor. Thanks, Michael.
Thank you.
Thank
Thank
you.
you.
Sure you don't want a donut now? Yeah, you can just hit the over here.
I don't know why I'm
I want one.
That's my first time.
Okay, next up is Marseille and Akina versus zip code 420. Mr. Putzig for the plaintiff, correct?
Yes, sir. On it now? Yeah, you can just hit it over here. I don't know what I'm doing. That's my first time.
Do you have your YouTube playing in the background?
Oh, you know what? I do. Sorry. Thank you.
Okay.
I was wondering where it was coming from me.
Well, the first time it was coming from my computer at the start of the day, which unfortunately was delayed by technical issues, but here we are. So, Mr. Putzig, I've read your motion. It does not appear that there's been any opposition to it. And no one has appeared this morning to oppose it. So I am going to grant your relief. I have a proposed order here. Which contains all of the necessary findings, which I endorse. I will sign that order and we'll make sure we get you a copy as soon as possible. Sir, any questions?
Thank you, Your Honor. And just a general question. I'm in Saginaw, so I don't practice often in Jackson. What is your general, do you have a case management conference or do you issue a scheduling order?
In business court cases, I have a pretty elaborate pretrial scheduling order that I expect the parties to confer on, and I normally schedule a scheduling conference where we nail down the dates that you aren't able to supply. Here, where we have a pro per defendant and a named defendant that is apparently in default, I'm less inclined to do a scheduling conference. Have you gotten notice of one?
No, that's why I'm asking.
If you go on my website, you will see my standard order format for business court cases. Why don't you just go ahead and do that yourself, submit it to me, and then if the dates look appropriate, I will enter them. Make sure, obviously, you serve the defendant when you send it to me so that they know what you submitted. But it's really not much point in having you confer with a non-attorney about the contents of that order.
Okay, that sounds like a
If
plan.
it appears reasonable to me, I'll just go ahead and grant it that way.
Okay, thank you, Your Honor.
You're welcome, sir. Have a good day.
You too.